Here's a detailed and exam-oriented explanation of privileged communication, with a special focus on the scope of privilege between an advocate and client under the Indian Evidence Act, 1872. Privileged communication, Indian Evidence Act, 1872. What is privileged communication? Privileged communication refers to certain communications which the law protects from being disclosed in court, even if relevant to the case. These are exempt from the general rule that all relevant facts must be disclosed. It is based on public policy to promote full and frank disclosure in sensitive relationships, e.g. lawyer-client, spouses, etc. Key characteristics: confidential in nature. Communication must be in the course of a protected relationship. Disclosure is barred even under compulsion of law, with exceptions. Section 122 to 129 of the Indian Evidence Act deal with these privileges. Types of privileged communications in India. Section, type of privilege, description. 122, spousal privilege. Communications during marriage are protected. State privilege. Unpublished official records relating to affairs of state. Official communications. Communications by public officers in official confidence. Police officers not compelled to reveal sources of information. Advocate-client privilege. Protects professional communications between lawyer and client. Advocate-client privilege. Sections 126 to 129. Section 126. No disclosure by barrister, attorney, pleader, or vakil. No legal advisor shall disclose: 1. Any communication made to him by the client. 2. Any advice given by him to the client. 3. Contents of any documents prepared in the course of professional employment. Applies even after the end of employment. Client alone can waive the privilege. Essential conditions. Condition requirement. Communication must be between advocate and client. In professional capacity, communication must be made during legal employment. Confidential, communication must be intended to be confidential. Exceptions to Section 126. An advocate can disclose if 1. Communication was made in furtherance of an illegal purpose. 2. He discovers that a crime or fraud has been committed after the communication. Extend Section 126 to interpreters, clerks, and servants of the lawyer. Section 128. Client can waive the privilege, expressly or impliedly. Section 129. Client cannot be compelled to disclose confidential communication unless he offers himself as a witness and refers to it. Important case laws. 1. M.S. Hoshiar Singh v's Emperor, AR 1937, all 62. Legal advisor not permitted to disclose communication even when summoned. 2. Siddhartha Vashisht Manu Sharma v. State, NCT of Delhi, 2010, 6 SCC 1. Legal privilege not available for communications made to commit a crime. 3. Kochuni v. State of Madras, AR 1959 SC 725. Held communications made for honest legal advice are protected even if it later results in a dispute. Hash, illustration. A consults a lawyer, B, and admits to theft, seeking legal advice on consequences. B cannot disclose the confession to court or police. This is privileged. However, if A tells B to forge documents, B can disclose, as it's an illegal act. Summary table, advocate-client privilege, principle, rule, who is protected? Client, and by extension the lawyer, applies to communication, advice, documents, when, during and after professional employment. Exceptions: crime, fraud, illegal purpose. Who can waive? Client only. Other covered persons: clerks, translators, assistants. Conclusion: privileged communications ensure trust and confidentiality in legal and personal relationships. The law balances public interest with individual privacy. Between advocate and client, the privilege is strong but not absolute, especially when crime or fraud is involved.